the court's award of alimony can be changed. What you don't know about Georgia alimony laws could cost you dearly in your divorce. Stay tuned and I'll explain. I recently had two people who have been divorced come to me, and what they had in common was they had both made really, really bad alimony agreements. What they didn't have in common is that one of them could be modified and the other one couldn't. Let me explain. The rules surrounding alimony in Georgia say that if the court orders a certain amount of alimony for you to pay or for you to receive, the court retains the ability to modify that award of alimony, meaning that the party paying the alimony or the party receiving the alimony can go back to the court and request either an increase in alimony or a decrease in alimony, depending on various circumstances, which I don't have time to get into right now, but just keep in mind, the important thing to remember here is that if the alimony award is ordered by the court, it can be modified. Now, sometimes alimony is arrived at during settlement negotiations. Can that award of alimony, can that agreement of alimony be modified? Yes, it can, unless there is certain language in there that says it is non-modifiable. I'll explain why. So sometimes in order to get a case resolved outside of court, the parties will agree upon an amount of alimony. And sometimes they will have language in there that says that this alimony is non-modifiable. If there is no such language in the agreement, then the alimony can be modified by the court. You would have to petition court for either an increase or a decrease in the alimony amount, but at least the court retains the ability to modify that award of alimony or that agreement on alimony. However, if you have an agreement on alimony that says it is non-modifiable, then the court's hands are tied. They cannot change that alimony amount, which means if you've paid too much, if you're paying too much, the court can't do anything to relieve you of that obligation. It also means if you feel that you're not receiving enough alimony and maybe the paying party's circumstances have changed, maybe they got another job, maybe they just sold their company or something to that effect, maybe they won the lottery, maybe they had some kind of a windfall that would otherwise allow you to request an increase in alimony. If you have signed an agreement that says you had non-modifiable alimony, well then you can't request an increase in alimony. So it's a double-edged sword. It works both ways, depending if you're the receiving party or the paying party, depending if you're anticipating your income or the other party's income to go up or go down. But here's what I want you to remember about this. This is what's so important. When you're agreeing on alimony, make sure that you are aware of whether the alimony is going to be modifiable or non-modifiable. So back to these two cases that came to me. The first case had a provision that said the alimony was non-modifiable. And I believe that they were paying around $7,000 a month in non-modifiable alimony. Now, this person had a really, really good job. They were making hundreds and hundreds of thousands of dollars a year. Then they had a medical issue and they had to take an extended leave from work. And when they came back, they were no longer able to do their job. They lost their job, but they were still on the hook to pay that amount of alimony for the entire duration because they had included language that said that the alimony was non-modifiable. There was nothing the court can do for them. There's nothing I can do for them when their alimony says it's non-modifiable. Now, let me tell you about the other person. The other person came to me recently and they also agreed to just a crazy amount of alimony. And they asked me, can this be changed? Can I get this adjusted? And I was able to tell them, yes, we can file for a modification of alimony based upon a change in circumstances that would warrant the modification of alimony. We can ask the court to do that. Why is the court able to do that in the second case but not the first case? And the reason is they did not have any language in their agreement for divorce. They settled the divorce outside of court. So they came to agreement. They had no language in there that said that the alimony was non-modifiable. So in the absence of language saying that it is non-modifiable, then it is modifiable. So something to remember is that the court cannot issue an award of alimony that is non-modifiable. If you resolve all your other issues in your divorce and then you just go to the court and say, look, we can't agree on alimony, will you make this determination for us? If the court issues an award of X amount of alimony, you can go back and modify that alimony. Now, you might be the receiving party, you might want to try and modify it upward. You might be the paying party, you might want to try and modify it downward. But the thing I want you to remember here is the court's award of alimony can be changed. It can be modified depending on the circumstances that happen after the divorce is completed, after some time has gone on, and after circumstances have changed. So keep this in mind. Think about this when you're either offering an award of alimony or receiving an award of alimony. But be very careful regarding alimony, because you want to make sure that if circumstances change beyond your control, you're not on the hook for paying a certain amount of alimony or for receiving a certain amount of alimony. Now, personally, if someone asked me, do you think it's better to be on the hook for a fixed non-modifiable amount of alimony as the receiving party or the paying party? What I would say is, if I'm the paying party, I would never want the alimony amount to be fixed such that I can't modify it. Because if I have to pay a certain amount of alimony and it's based on a certain amount of income and a certain expectation of that income continuing for a certain amount of time, I want to make sure that if something happens, if I get injured, if I lose my job, if I get sick, if whatever could happen, I want to make sure that I can modify it so that I'm not paying this amount of alimony based upon, a commensurate amount of income. I want to make sure that if my income drops, I'll have the opportunity to bring my alimony down as well. I think it's a much, much, much greater risk for the party who's paying the alimony to have a non-modifiable alimony clause in a settlement agreement. Now, if you're the party who's receiving the alimony, what is your risk? Well, your risk is that, okay, so the income of the paying parties here, the alimony that they agree to commensurately is right here. So your risk on a non-modifiable clause is that their income shoots up to the sky and you can't go back and try and get an increase in the alimony. But if you're okay with the alimony amount here and their income shoots up to here, you should be happy for them, because frankly, they're having good fortune in their life, and it also increases the likelihood that you're not going to have to worry about them failing to make their alimony payment as ordered, or I should say as agreed to, and then turned into an order by the court. Hey, thanks for watching this video. I hope you found it helpful. Be sure to click subscribe, like, follow, whatever is appropriate for the platform you're watching it on, and turn on the alerts so you get notified when we post our newest videos. Please share these videos with people you care about who need to see this information, repost them, and let's get this information out to people who need to know. Also, leave us some comments. Let me know if you agree. Let me know if you have questions or suggestions for other topics. I really want to hear what you have to say. Just keep it polite. Remember to join our Facebook group at Georgia Divorce and Custody and join in the discussion. And as always, I look forward to seeing you on the next video.